Chapter 22 deals with international arrangements. International arrangements refers to the process by which you can file multiple patent applications in multiple jurisdictions. Now, this is a broad arrangement between various countries. That's why we call it an international arrangement. And there are two types of arrangements. We will see that soon. There are two types of arrangements wherein you could file an application in one country, regard that as a priority document, or that filing based on which you had made the filing as a priority date, and follow it up with filings in other country. Had it not been for an international arrangement like this, assume that there was no such international arrangement between countries, then the only way you can file patents will be to have different teams ready at different patent office around the world and to file the patent on the same day in such a way that one filing does not amount to disclosure of the novelty in another office. So the only way you could preserve the priority and the novelty of an invention is by filing multiple applications, by having teams to do that in different countries. So the international arrangement actually helps us because it dispenses the need to be physically present with a team in different countries to make the application at the same time. Now, the difference is priority is important to know who has the claim over an invention. Now, assume that you have an invention and you have placed 3 teams in 3 different countries to file an application, and you do that on a particular day. On the same day, in a 4th country which you have not done, which you have not covered, there is another person who files an application for a similar invention very close to yours. Now, that could lead to problems because that person can claim that he had no knowledge of your application and he filed it in the same day in a different country. Now, the international arrangement in a way helps us to resolve those issues, because if you file an international application or a basic application as the Act calls it, then based on the basic application you could follow up many applications in different countries and they will all take the priority from their international application or the date of the basic application. Now, that can broadly be done in 2 ways. One is to make a convention application and the other is to make a PCT, Patent Cooperation Treaty application. Now, you will remember in Form 1, when we took you through Form 1, there was a column in Form 1 which dealt with types of application. You could file an ordinary application, that's an application focused on India, an Indian application. You could file a convention application, and the third type was a PCT national phase application. The 3 types of applications you can file in India are ordinary, convention and a PCT national phase. Now, convention and a PCT national phase are covered in this chapter. Now, the details of a PCT you may not find it here because PCT is a separate treaty in itself, the Patent Cooperation Treaty, which is administered by the WIPO, World Intellectual Property Organization. So, they have dedicated websites, they have dedicated regulations. So, the details you have to refer to those regulations to understand how the PCT process works. But the Act covers what you need to know about international arrangements, and this will be important from the perspective of taking examinations. What will be asked is what has been covered in the Act and the rules. Rules are elaborate, because I just need to bring your attention to the rules. We had an amendment done to the rules in 2013, and 2013 is an important year because that is the year India became an international search authority and India also became a international preliminary examination authority. So, you could file an application in India and you could get a Indian international search report and an Indian international preliminary examination report. So, 2013 the amendment carried out in the patent rules, that is from rule 19 the Rule 19, which has Rule 19, Rule 19A up until Rule 19N. All these rules were introduced to bring in the details of that are provided under the Patent Cooperation Treaty, by which India became an international search authority and an international preliminary examination authority. And you will recollect that choosing India as an international search authority or an international preliminary examination authority is one of the ways by which you can have an expedited examination. So you will have to look into the details in Rules 19 to understand, and 19 followed by Rule 20, 21, 22 and 23 to understand how the PCT process works. There are various institutions under the PCT, there are bodies, there are reports, there are timelines. 133 talks about convention countries. Now, when the Patent Act came into force, this section was substituted in 2005. Earlier, there was a notification of convention countries, and now you have convention countries defined in they are defined in section 2(1)(d). Convention country means a country or a country which is a member of a group of country or union of countries or an intergovernmental organization referred to as a convention country in section 133. So, section 133 refers to what a convention country is. Any country which is a signatory or a party or a group of country, union of countries or intergovernmental organization which are signatories or parties to an international, regional, bilateral treaty, convention or arrangement to which India is also a signatory or a party. So, it could be anything. It could be a treaty, a bilateral treaty, a convention, an arrangement or a regional arrangement or an international arrangement. The requirement is India should be a party to that. So, we understand a convention country as any arrangement to which India is a party, India is a signatory or a party, and which affords to applicants for patents in India or to citizens of India similar privileges as are granted to their own citizens or their member countries in respect of grant of patents and protection of patent rights shall be a convention country. Now, which means India should be, the first requirement is India should be a signatory or a party to that arrangement or that agreement or that treaty, and that arrangement or treaty or convention should offer reciprocity, meaning which the rights that are offered to Indian citizens, India will offer to the citizens of that country, which means the countries respect each other's rights. So, on the basis of reciprocity, India can be regarded as a convention country if India is a signatory or a party to a convention and the convention treats Indians like how it treats its own citizens. So, this is the test for a convention country. So, if India is in a party to an arrangement and the arrangement treats Indians and citizens or applicants for patents in India or citizens of India like how it treats its own citizens, then that is regarded as a convention country. Now, notification as to countries not providing for reciprocity. Now, we said that in 133 the important principle was reciprocity. If countries do not provide for reciprocity, then there is a process by which any country specified by the central government in this behalf by notification, if that country does not afford to citizens of India the same rights in respect of grant of patents and protection of patents that it accords to its own national, no national of such country shall be entitled either solely or jointly to apply for a patent in India, to be registered as an assignee or to hold a license. So, if a country does not offer reciprocity, then 134 says that the national of that country will not be entitled to apply for a patent, register assignee or a proprietor of a patent, or apply for a license under a patent of this act. Now, convention applications are mentioned in 135. Now, in section 6, we saw that an application can be made by 3 people or 3 categories of persons: a true and first inventor, assignee, and a legal representative of a person who is entitled to apply. These are the three categories. Now, without prejudice to that, a person who has made an application in a convention country, and that is the first application he makes in a convention country. There is a convention in which many, say we can take the Paris Convention, where many countries are parties to it. So, a person makes an application for the first time in one country, say he makes an application in the United Kingdom. That application will be called the basic application. The application that he first files will be called the basic application, and that person or a legal representative of the assignee of that person makes an application under this act for a patent within 12 months after the date of the basic application was made. Now, what is the requirement to make a convention application? An application has to be made in a convention country. Within 12 months of making that application, because it is the first application, it will be called the basic application. Within 12 months of the basic application, an application had to be made in India. The priority date of the claim of the complete specification, being a claim based on the matter disclosed in the basic application, is the date of making the basic application, which means the priority date is the date on which the first application was filed. It is a logical arrangement. The first date on which the application was filed will be the date of the basic application, because that was the first application that was filed, but it could be filed in a different country. So, this we saw in the case of provisional and complete specification. The complete specification could take, in some instances, it could take the priority from the provisional. What was the requirement? The matter should have been fairly based on the provisional. If the claims are fairly based on the provisional, the claims can take the priority from the provisional. Now, the claims based on matter disclosed is the language used here. You can see here claims based on matter disclosed in the basic application. This is nothing but the concept of fair basis. Matter disclosed is, it is based, the word fairly is missing, but it is understood as the same thing. So, just how we had fair basis for claims in the complete specification, if they had been fairly based on a disclosure made in the provisional, you could claim the priority of the provisional. Similarly, when you file an application in India and the claims or the claim is based on a matter that was disclosed in a basic application, which, as we had mentioned in our example, is an application filed in United Kingdom. So, you could claim the priority of the application in United Kingdom. The only requirement is you should file the Indian application within 12 months of filing the application in the United Kingdom, which is what the Act refers to as the basic application. So, the concept of priority when it comes to a convention application is similar to the concept of how a complete specification takes its priority from a provisional specification. But there are some differences here, because in this case both are complete. The basic application is a complete filed in United Kingdom, and the Indian application filed later on within 12 months is also a complete. So, this is complete taking priority from another complete, and we had also seen in similar instances within the Indian Patents Act. So, this arrangement allows, the international arrangement by filing a convention application allows you to take priority from another application filed in another country. Provisional and complete were pertain to applications filed within India, within the Indian Patent Office, but here by this arrangement you are allowed to take priority from a different application filed in a different country. And you have similar provisions like in respect of an invention, 2 or more convention countries, the period of 12 months shall be reckoned from the earliest application. Just how we had, if there were multiple provisional applications followed by complete, then the date, the 12-month period will accrue from the date of first filing from the date of the first provisional filed. Subsection 2 talks about cognate applications, applications which are related. The priority will be from the earliest date. Now, 3 you will find introduces PCT into the scheme. Now, this was an earlier provision, now in which only pertain to convention countries, and 3 was inserted in 2005 because India became a party to the PCT at a later stage. So, this was incorporated as an amendment. In the case of an application filed under the Patent Cooperation Treaty designating India and claiming priority from a previous filed application in India, the provision of 1 and 2 shall apply as if the previous filed application were the basic application, provided that a request for examination under section 11B shall be made only for one of the applications filed in India. Now, this is a case where if an application is filed in India and you can file a PCT application based on the earlier filed application. The earlier filed application will do the job of a basic application. So, the PCT, the arrangement is different from the convention application. In PCT, you file one application and you file a PCT application, and then you can choose the different jurisdictions that you have to enter, and you will be given a time period 30 months by which time you have to enter all the other jurisdictions. So, the convention application is one route to enter multiple jurisdictions. The PCT, the Patent Cooperation Treaty, is another route. 136 deals with some special provisions on how to determine on post dating what should be accompanied with the application. You cannot file a international application based on a provisional. You have to file your complete. So, these requirements are there. And how do you deal with multiple priorities? 137 deals with instances of multiple priorities. We had already seen the issue of multiple priorities when we covered section 11 and also when we covered section 9 on a provisional and a complete based on the provisional. Similar rules apply here, and there are some supplemental provisions on convention applications. I had already mentioned that the relevant rule for PCT applications and conventional applications will be rules 19 to 23.